Hello, welcome to our weekly COVID updates for employers and employees on immigration status. First, I hope you all are doing well and everyone's being safe. And today we thought we would talk about an issue that I have been seeing coming up quite a bit, which is related to status. You know, how does changing status or extending your status affect your current status now? If you want to travel during this time, how would that impact your status? So we thought that this would be a very, timely discussion to kind of address some of those issues. Okay, so let's get started. So last week we talked about anticipated executive work orders, that there is still that buzz and perception that the president is going to, through executive orders, address some additional restrictions, but there's only so much he can do as pursuant to the executive order. So we talk about that limitation so that you understand and can plan, which is critical, what you need to do to address any, anticipated restrictions. Then it's not just the president. The USCIS can, through rulemaking, issue new restrictions, as they had been planning over the past some time. But even that is subject to the Administrative Procedures Act. So we talk about the timing of those types of restrictions and, would you have the ability to make any options or address any, changes that may take place. And then lastly, the highly anticipated premium processing has been resumed, but there's going to be resumed in phases. So we outline what those phases are so you'll know when you would qualify to upgrade your existing petition to premium processing. So today, however, we're going to be talking about like I said, different statuses and the different rules for different types of status. And, but if you didn't get to check, listen to our presentation last week, then, you can take a look at it, that and other presentations on our YouTube channel. And please subscribe and share with your friends if you think it may be pertinent. We talk about everything from, the 60-day grace period on H's, changing your employment from, full-time to part-time, a number of things that you're probably having to deal with during, COVID. So, take a look at that, and I think that'll be really helpful. Like I said, we talk about the president's authority, the proposed changes, strategies so you're proactive and you'll know what to do. And then finally, other updates, on the premium processing. So today, let's talk about, a lot of these words, terms are really important. And the three things that I think most people get confused about are the question of a valid visa, your stay in the United States, and status. So it's really important to understand how they intertwine and what is relevant at what point. So when you talk about a visa is merely an entry document. You don't need a valid visa to stay in the United States. You do need a valid visa to enter the United States. So that's where that becomes really particularly relevant, is when you are making an entry into the US. And so another thing that most people don't understand is even if you change employers, the interesting thing is that you may have a visa from employer A, and then you file a change of employer to employer B, but you never got a visa for employer B. Your H-1B visa for employer A is still valid, so you can travel on that visa, even though you've changed employers in the interim. You would just present, when you enter at the port of entry, your approval notice for your new change of status, and then you'd be able to enter on your previous visa. But it's only an entry document. So, for example, a person can enter the United States on an H-1B visa. The visa could expire. They could have applied for an extension in the U.S., and their status is not impacted by that. Why? Because what governs your status is your I94 card. Now, this is something really important. I think I've said this so many times, that when you enter the United States, previously they give you a hard copy of your I94 card for you to put into your passport. Now there's an electronic copy. I tell people, as soon as it's feasibly possible, please go online and review and print out your I94 card. Not only because that's your work, that's your authorized status in the US is the I94 card. Your visa is not, your passport is not, it's your I94 card. So it's good to keep that with you. Secondly, sometimes they make mistakes. So if they make a mistake, it's easier to get it corrected the sooner you ask them, that you notice that there's a problem. And a lot of times people assume that there's not going to be a problem, and they find out months later, and it becomes a bit challenging to get it corrected. So your entry document is your visa. What governs your stay in the United States, your validity, is your I94 card. So again, the USCIS has said that the period of stay, as noted on your I94 card, is, your status, not your, it is your authorized stay. So, but there are other, status is a very, a more, I would say, it's not a black and white question. So it depends on what your non-immigrant status is, because there's a question of having a valid stay, but maintaining status can be something totally different. So the violation of status, so the I94 card, you could have a valid I94 card, and if you haven't maintained your stay, you could be out of status, even though you've got a valid I94 card. And so let's talk a little bit about what it means to maintain stay, because it's different for different non-immigrant classifications. So one of the overriding concepts that we have to keep in mind is when you enter on a non-immigrant visa, each non-immigrant visa has a purpose, permissible activities, and so you have to, whatever your classification is, you can only engage in activities that are consistent with your status. And like I said, each non-immigrant status has different types of requirements. So for F1 students, the critical thing is, and there's some nuances to this, but the critical thing is the maintenance of status is dependent on two things. You've either got to maintain a full-time course of study, or you've got to be working in your authorized optional practical training. And then, of course, the 60-day grace period. Whoops. Sorry about that. I am having an issue with, let's see if I can undo this for a second. It should have. Let me go here and remove the Zoom, because I think I must have screwed that up. Okay, this is what I wanted to show you. Okay. So the F1 student, in order to be maintaining status, what is a full-time course of study? Well, each school has a very different set of hours that it outlines as a full course of study. So the other thing that most people didn't know until all the raids took place is, except you know, right now during COVID, they're making an exception, but you can only take only one online class at a time. So full-time course of study has to be going to school, bricks and mortar. And then finally, there are issues if you try to use it as a mechanism to obtain work authorization. As you've heard in, I think, the case in Detroit and a couple of other academic institutions where that was a problem. Okay, for F1s on optional practical training, for curricular practical training is where you are getting real world business training as part of your curriculum. So it's embedded in your curriculum that you get some experience, work experience, for credit for those classes. So typically you have to be enrolled for at least one full academic year. Graduate students are exempt from this requirement if the degree program requires immediate participation. So this would come up, all these issues come up if you're trying to subsequently later file for a change of status, let's say from F1 to H1. So at that time, you want, you know, they would review that, the USCIS, and if they see that you've gotten curricular practical training before the 1 year period, they're going to want to have proof that your academic program required it. So I always tell people as a practice pointer that you should try to get that sooner rather than later, because DSOs change and policies could change at school. So it's better if you get it up front. You must have an employer for your CPT, can't be self-employed, and the employment's got to be related, of course, to your field of study. But most importantly, and a lot of students, we've gotten a lot of folks that have had problems with this, they don't realize that they have to get their I-20 endorsed by their DSO before they can start work. Just because you have CPT, the school authorizes CPT, doesn't mean that that automatically allows you to work without some sort of authorization document, and your I-20 endorsed by your DSO is what you would need. We have a question. Can an F1 student work remotely? Yeah, I mean, yes. For OPT, there are really not a lot of restrictions when it comes to remote work. There are some restrictions for STEM OPT, because STEM OPT, implicit in that is that the employer is actually training you and reviewing your work. So you would want to make sure it's documented how that review is taking place. But that is permissible. F1 students on OPT, the one thing that you want to keep in mind that the OPT, you cannot have an aggregate of 90 days of unemployment. So there's no grace period when you're calculating that 90 days. And so, in students who volunteer intern for 20 hours a week, that wouldn't be counted against the, you know, that is permissible. So you can work without, I know we've had questions where people have said, okay, can I work without pay? Yes, but you'd have to still demonstrate it's in your field of study. And then you'd have to demonstrate that it is truly, you know, work that you are doing. So you want to make sure that, you know, you're clear about it. We have another question. What is the difference between OPT and CPT? Okay, very good. Great question. So CPT is, like I said, curricular practical training. You are getting practical training or work experience in lieu of, you know, class credit. So it's tied to your curriculum. Optional practical training is usually leveraged after you finish your course of study. So optional practical training is where you're allowed 1 year to get some real life work experience in your field of study in the United States. So those are the nuances between the two. Then there there STEM OPT. So STEM OPT limits unemployment for 150 days. Remember, STEM OPT, if you're in a STEM field, in addition to the 1 year optional practical training, you get 2 additional years. You have to be in a STEM field. You have to fill out a training program. It's a little more involved than the regular OPT. But here you have 150 days applied to the 3 years of where you can be unemployed. You have to report your periods of unemployment on your form, so you have to make sure to do that. But that is so you've got CPT, you've got OPT, you've got STEM OPT. Now, the other thing on the issue of maintaining status is a lot of people on an F1 will get a master's degree. Then they typically will try to get another master's degree with the promise of getting CPT on day one. Now, before the USCIS wasn't as strict on it, but recently they really have been. And the rule is a student may be authorized for 12 months of practical training and be eligible for another 12 months of practical training when he or she changes to a higher educational level. So you could go from CPT to, from a master's program to a PhD program, and then you would be eligible. But if you've taken CPT and you've done your 1-year OPT and you're going into the same level program, you may have issues. And where does that come up? The issues come up when you apply for an H-1B. Because when you're applying for a benefit, like a change of status or an extension, that's where they look to see if you've been maintaining status. And if they find that you haven't been maintaining status, then you could have a problem getting your H-1B. So, H-1Bs, maintaining status on an H-1B. Now, this is really interesting because H-1B, there are a few others within the HCAT classification, but H-1B, you don't just file the petition with the USCIS like you do for like an L1 or an E2. For the H-1B, you first have to file with the Department of Labor. So the employer makes certain attestations with the Department of Labor with regard to, the terms of employment. And so he or she, there are some obligations that are associated with that. One being that they have to pay the salary for whatever stated on the I-129, because you file the labor condition application, it gives you the prevailing wage for the particular position that you're undertaking. And then on the I-129, the employer outlines what wage they're going to pay. And usually it's an annualized wage, like a yearly wage. So they have to pay that at least prorated at a monthly basis. Commissions don't, any wages that are not guaranteed do not count towards that. So what does that mean? The reason why it becomes relevant is to ensure that you're maintaining status when you try to extend your status or change your status on an H-1B, or even when you're going through the adjustment of status process, they'll want to see proof of pay. So that is something that is really critical for the H-1B, is they can't be furloughed. And you can take personal leave, that's permitted, but there's no benching. You can take personal leave, you can amend to part-time, and remember that if your if your period of validity is still valid, you can take a 60-day grace period. But other than that, that would be problematic. Here's a question. We have faculties who are hired for 9 months term. It is allowed. There is a special exception with academic faculty, so that's not a problem, that it's 9 months. Because even though they are working for the college term of 9 months, they're being paid, throughout the year. So, and they're often doing other things during the summer program as well. So they're employed by the institution for that full year or on an annualized basis. I am on an H-1B working remotely, and I live 7 miles from my office. Do I need to amend my petition? Well, that's a good question. So if you're working remotely, notwithstanding COVID, but anytime, the rule of thumb, and we've got a YouTube video, I think it's like our second one, so you may want to check that out because I go into it in greater detail in the video. But the deal is, if you change your work location, typically you have to file an amended petition. The exception, there's a few exceptions to that. One of them happens to be if it's within the same MSA, Metropolitan Statistical Area, or it's within commuting distance. 7 miles seems like it's commuting distance, even, you know, for most locations. But commuting distance is not defined. So what's commuting distance for New York may be different from what's commuting distance in Richmond, Virginia. But the standard is, as long as it is normal for people to commute within that boundaries, you don't need to file a new LCA. You do need to post a notice of filing. That means you post a notice, and for right now, you do it in your home. And like I said, if you look back on our YouTube video, it'll tell you the details, or email me and at info@cellolaw.com, and I'd be happy to send you that memo. But it is permissible. So maintaining status for the H1 is really dependent, as you can see, on the salary. Whereas with the F1, it was all associated with their study. Because remember, each one, the purpose is slightly different. That's why that whole idea of maintaining status, you know, is not one that, it's not one size fits all. Now, there's a couple of terms as we're talking about maintaining status that we should be familiar with. So one of them is authorized stay. Authorized status is the period of admission. So it's the period authorized by the Secretary of Homeland Security or the Attorney General. And they're not interchangeable, because sometimes you may be in a period of stay authorized by the Attorney General, but that doesn't necessarily mean that that's a lawful status. And I'll explain that in just a minute. So, like, for example, the best example is when you are getting ready to file for a change of status, when you file for the change of status, or you file for an extension of status, your current status may expire while it's pending. So you're not in a lawful status, but you're in a status authorized by the Attorney General or the Secretary of Homeland Security. So, and the reason why that's become significant is, in addition to understanding what authorized status is, it's important to understand what unlawful presence is. Unlawful presence is, you know, a person, you know, it can be triggered by a number of things. The one thing that comes into mind for most people is that when there's been a violation of status, or when the expiration of their current status takes place. And this becomes, you know, it's now with the denial rates become really high, that's where it becomes really a concern. So why is there a concern about unlawful presence? Because unlawful presence can trigger, you know, the 3-year, 10-year bar. So if you accrue, you know, more, you know, less than 180 days of unlawful presence, you could trigger the 3-year bar. That means you're barred from entering the United States for 3 years. If you are unlawfully present for more than 180 days, for 180 days or greater, then you trigger the 3-year bar. If it's over 1 year, then you trigger the 10-year bar. So that's why it's really important to understand that relationship. So when you file an extension or change of status, even though your current status may have expired, it's like your status is frozen. So if that petition is subsequently denied, then you would start accruing from, you know, the date of denial. And, you know, people who are F1s, their duration of status. So the only time they start accruing unlawful presence is if there's a decision by, you know, DHS, or a decision by a judge. So if there's a denial, that's when you would start accruing unlawful presence. Furthermore, just as a side note, and I've talked about this previously, if you're filing for an extension, let's say, especially for an H-1B, you're in H-1B status, you're filing for an extension of H-1B status, there is, within the I-9 regulations, which governs how employers check to see whether their employees are authorized. It's a process all employers have to go through. There's something called the 240-day rule. So as long as you file a timely extension, that's really important, timely. That means you have to file whatever you're going to file, whether it's a change of status or the extension of status prior to the expiration of your current status. That's really critical. If you file it afterwards, then you don't get the benefit of the tolling of your unlawful presence. It would be triggered from the day, your expiration. But for H-1Bs who are H-1Bs, L-1s, who are filing for an extension, they can work for 240 days while the extension is pending. So I wanted to let you all know this. Unlawful presence and extension of stays, and how do they interrelate? As I said, if you file a timely, non-frivolous, so a frivolous application is where you really don't have a basis for filing or filing for the benefit, immigration status, but you're doing that just to kind of file something and bide your time, that it would be deemed a frivolous application. So let's see what the question is. Is the employer obligated to offer and to pay one-way ticket to a laid-off employee? If not offered, can the termination be determined from the day the ticket's been offered for the grace period purposes? Well, here are two things. Number one, your grace period is, remember, either 60 days from the date of termination or until the expiration of your validity of stay on the H-1B. So if your validity is greater than 60 days, then you get the full 60 days. If it's less than 60 days, then you don't get the 60 days. If you're trying to get the grace period because your extension has been denied and you're no longer valid status, you don't get the grace period. So those are some issues with the grace period. The other thing, the employer is required to offer to buy you a one-way ticket to your home country. Now, they don't have to give you money in lieu for it, and often what employers will do will, give you, tell you if you want a one-way ticket, we'll buy it for you. Your 60-day grace period for purposes of this is the date of termination. Were you given notice? How did they tell you? So that would dictate when the triggering of your 60-day grace period. And, often there's a process that they go through, hopefully there is, but, where they formally let you know that, you're furloughed or, to some extent. Can I file for unemployment benefits if I'm an H-4 EAD and if I'm furloughed? Will there be any immigration impact? No, unemployment benefits, unlike other type of public benefits, are benefits that you pay into. So, there are deductions that the employer is making and you're making for unemployment benefits. So you've already paid into that. So it's not, it would not be subject to the public charge bar. I had students who are on an F1 who told me they are pursuing with lawyers how to get green cards in order to permanently stay in the US. Is it true? And which visas do legally permit status change from non-immigrant to so easily? Well, I hope they're doing it the legal way. There are a lot of very unscrupulous people that are trying to take advantage and will file things like frivolous applications and other things that can get people into trouble. So they should be careful. But we have done that for students before as well, especially if they are eligible for something called employment-based second preference, if they've got a master's degree or its equivalent, and they're not from a country that's oversubscribed, like India or China. So if they're from some other country other than India and China, that means that's the country that they were born in. Doesn't matter if you have a citizenship from another country. For purposes of visa backlog, they look to the country of birth. So if you are from a country that is not oversubscribed, then potentially you can get a permanent residence in a 1-year time frame. The other thing is extraordinary ability or national interest waiver. If they're doing work that is, very unique, then they would be eligible for one of those classifications. So it is permissible, but if these are your students, I would try to find out how they're getting it done. Like I said, the one thing I would not want to happen is to have them try to, without fully understanding what the implications were, have someone tell them that they can file something and it's not a legal process. So, if you want to email me privately on that, email me at info@cellolaw.com. I'd be happy to help. I know I met a number of parents last time I was overseas, and their children were here studying, and the parents, they took a loan out on the only property they had. They scrounged money from here and there to send their kids here, and it would break my heart if, with so many people relying on these kids to actually make sure that they're on the right path, that if they were somehow not told clearly what the implications could be. It could be a very valid pathway. Like I said, we've done that before, but it's very limited because a perm process, could be done in a year. But if there's no available visa number, that's not going to really benefit them. So that's why it's only for countries where it's not oversubscribed. If we file a change of status along with an extension, it doesn't get approved. Does that cancel the previous visa status? It depends. For the most part, yes. So, one way to maybe circumvent that, instead of filing for a change of status, file a change of status, but file it for consular processing. I would be more concerned if you're filing for a change of status for a B1. That could be more problematic, but if your change of status petition is denied, then you're going to have to depart the United States. So one way to overcome that is to file a petition for consular processing. Once that's approved, then you can go overseas and consular process, or then you can even mend, and if you're still in valid status, change your status to the new status. The other thing you could do is, possibly, look at, just make sure that you're filing for something that, because premium is back, it's not available for I-539. So if you're filing for an F1, change status to F1 or B1, you're not going to leverage premium processing. But, it in phases in June, premium process will be instituted for other types of filings. When employer offers an extension, how can a worker know the extension was filed and acknowledge if the extension was filed and granted? Well, for practical purposes, you should get a copy of the receipt notice. So ask the employer for a copy of the receipt notice, because that is your status in the US. So if you were stopped or there was any question, a lot of times for driver's license, in order to get the driver's license is tied to your your validity period. So if your validity period has expired, you'd have to show proof to DMV that you have an extension filed. And so those are some of the ways in which, but you are entitled to that. So I would ask your employer for the receipt notice. And if he says he hasn't gotten the receipt notice yet, When the extension is filed with the USCIS and they cash the checks for the filing, all the, immigration USCIS filing fees, once they do that on back of the check, they stamp it with your receipt notice number. So even if you can get a copy of that, you would know that it was timely filed. But, this is your status on the line. You are responsible for maintaining status. So I would make sure that you get a copy of either the, have them give you the number on back of the canceled check or the receipt notice. Is it true that there's a 30 grace period after H2A? Or expiry date for the H. Are you talking about H2A workers? Are you talking about, because it's H2A visa or I94 expiring to return to the country of origin? So I'm not quite sure whether you meant it to be an H2A question or whether it's a H1B question. Is it true that there's a 30-day grace period for a worker to return to his home after the expiration of his visa date? What about the I-94 expiration date? If not the same as the visa expiration date, ask in the context of an H2A visa holder. There are different grace periods for different statuses. For the most part, it's usually a 30-day grace period. I think that there was something that was outlined recently for H2A workers. So if you don't mind emailing me at info@cellolaw.com, I can check on that and let you know. So I'm giving you whatever the most current information is on that. So if you could just email me, I'd be happy to send you the information on the grace period for that. So like for F1s, it's 60 days. For J1, it's 30 days. Typically, for H1s, there was no grace period statutorily, but they talk about a 10-day grace period now. So it's different for different classifications. And currently, especially for H2As, they've gotten, they're trying to make some accommodations. And so I just want to check to make sure on that before I let you know. In the time that passed from January to now, what has been the success rate on L1As have you seen? We haven't had any issues on L1As. I know that the stats are not very good for L1As, but personally in our office, we haven't seen any problems either with getting the initial L1A or getting the L1A approved. So, and premium processing will be resuming for everyone in phases. So, that may be an option to upgrade to premium once, your particular classification is eligible. But we haven't. I mean, I think the biggest problem would be if there was no, that on the original L1A, you really didn't expand the business or do anything else. I think that's the only time that it would be problematic, but we've been able to successfully even address that because we're able to talk about it more in terms of, what is, for this type of industry and business, what kind of startup time do you need in order to really penetrate? And that's been helpful too. Can I change client on an H-1B receipt? How should my employer file for the amend and extend? Yes, you can file a change of employer and they would just use the receipt notice. As long as your extension was filed prior to the expiration, you are in an authorized stay, so they would state that and then change employer. And so I had filed for my I-130 for my sibling. It was approved in 2015. I'm not sure to what address I put in there because I never received the approval notice. Yeah, what you can also do is you can contact NVC because once the I-130 is approved, it goes to NVC, and siblings, you know, it takes a really long time for those types of petitions. So you may want to call NVC, and they may have the information. They're going to be contacting you anyway when it's closer in time, because for you to undertake the next steps. So that may be, you know, someone you want to connect with. Okay, yes, I think I just answered that question. Can we apply for an H-1B transfer while the H-1B extension is pending and the I-94 expired? Yes, you would use the receipt notice to prove that you filed prior to the expiration. And your attorney or employer would highlight how you filed in a period of authorized stay, which is a status authorized by the Attorney General. So this is what happens when you file for an extension of stay. So remember, I told you that there was a difference between a lawful status and an authorized stay. So a lawful status is the period of validity on your petition. So that's your lawful status. So I'm an H-1B visa holder for the period of validity that's on the approval notice, or period of validity that's on my I-94 if I had departed and re-entered the United States. But let's say your period of validity is getting ready to expire, and you file for an extension of that stay, like some of the questions we had. And in between, while it's pending, your period of validity has expired. So because you filed a timely extension, then you are in a period authorized, they say, by the Secretary of Homeland Security, by the Attorney General, I think in the INA regulations. So it's authorized, but you're not in any status. So what is important is you can't do bridging. What is bridging? So bridging is, so if you have filed, like I said, a timely extension or change of status petition, you don't accrue unlawful presence as long as it's pending. But because there's a difference between a lawful status and an authorized status, a lawful status and a stay authorized by the Attorney General, let's say you file for an extension and then suddenly you want to file for a change of status to a B1 because you're concerned your extension on your H-1B is not going to get approved. Well, that's called bridging. And so because the second application that you're filing, after you've already filed this timely application before your status has expired, you are not in a lawful status. You don't get the benefit of tolling. So that subsequent application is not going to stop you from accruing unlawful presence if the first one is denied. So that's something to keep in mind. A lot of people just keep filing things, and that's called bridging. So your initial filing, any filing that you file while you're in authorized, while you're in lawful status, while you're in the period of validity as outlined, then that's permitted. Anything filed after that, you are in a stay authorized by the Attorney General, but you're not in a lawful status. So you don't get the benefit of that tolling of the unlawful presence. So let me see if there's any other questions. There seems to be a couple more. How could an employee know if the employer revoked the H-1B? Well, you could try checking on the USCIS status to see if it's been revoked. By typing in your I-797 approval number and seeing what the status shows. Does the employer need to offer pay to an OPT or CPT candidates for internships or anything else? Does a firm need to be registered, or can the firm accept these candidates? Well, any company, the key for CPT and OPT is, well, if you are going to pay them, you can never pay them below the minimum wage because you can't, it would be unlawful. So that's A. B, if you're not going to pay them and they are volunteering to work for you, as long as it's in their field of study and as long as it's a true internship, then, you know, it shouldn't be a problem. There are some variants and issues with regard to who benefits from the internship, right? Is it the employer or the employee? If the trainee is benefiting because they're getting real life experiences, experience they wouldn't have, it augments their academic education. But those are not so much immigration rules as they are wage and hour. So that's the only thing that I would keep in the back of my mind. Sometimes internships are truly for the benefit of the intern, even though, you know, the employer may also be benefiting from that process as well. But the OPT and CPT regulations don't require that the employer pay the trainees. And you don't need to be registered, you know, any firm can accept this. It's only with STEM OPT that you have to be registered for E-Verify, and it's only with STEM OPT that there is a wage, you know, kind of requirement or limitation. Does a traffic offense in the US get reported to the US consulate abroad? Would that affect an interview for visa? If it's a moving violation, like a speeding ticket, parking violation, driving without your tail lights, it's fine. If it's more of a violation with regard to a DUI, it depends on how many, and some consulates, you know, are taking greater issue with that than others. So I would just assess to see, you know, if it's a straightforward traffic violation, like I said, speeding, driving with the tail light out, parking violation, that's no problem. Is it lawful to drive in the US with a Mexican driver's license? No, typically it's not. I mean, a lot of people will drive with an international driver's license, and most law enforcement can't tell the difference, but typically you need a US driver's license to drive in the US. I'd filed my H-1B extension, and I'm on an extension receipt. My I94 expired May 10th. Can I transfer before my extension gets approved? Yes, you can transfer before your extension gets approved with a new employer. So you would, because it was filed timely, you would just, you know, prove that you had filed timely, and and then, file for the change of employer. Can a foreign national change status from undocumented by permanent residence by marrying a U.S. national? If they entered with inspection. So there's two types. People who may have entered on a visitor visa and overstayed, even though they're not in lawful status, could do that. But the rules changed several years ago where you would have had to enter with you have to enter, you have to be inspected by an immigration officer. Another exception could be if you've been here for a really long time. In 2001, and of course in the Reagan 99, there was some legislation that passed that would allow people who are here undocumented to then change status to that of, a permanent resident. So if your family members filed during that time, let's say your parents were here and they had tried to go through that process, especially in the 2001 timeframe, but it either didn't get approved or didn't move forward, you could be grandfathered into that. And if you can prove that it was a non-frivolous application, it was filed in 2001, you can benefit from that now. But those would be the only circumstances. What is the best way for a Mexican national to acquire legal status after marrying a U.S. national. I think I just went over that now, that those are the only two situations that you'd be able to do it. You can file a waiver, but in this current climate, I wouldn't do that. I would wait to see what happens with the election and with the new president. If there is a new president, you could rethink that at that time. So the I-130 would be filed. If they allow for resuming, that you can wait for, you file your waiver, you wait for the waiver to get approved, and you go overseas, consular process, and come back. But I wouldn't do it in this administration. The current 907 form has an expiration date. I think there is a new one that's been issued, and you can check that by going on the USCIS website, and you would have the latest I-94, 907 there. So I know that you all are listening to our YouTube, videos. Please, we use different mechanisms to convey different messages. Sometimes we have more detailed information and it's quicker when there's some news that's immediate or imminent. We send it out in our newsletter, like for when premium processing resumed, we sent that out in our immigration updates. So if you haven't subscribed, subscribe. Click on the link, and once we've uploaded it to our YouTube channel, and then you can get the latest in immigration, because this is really important. Like I said, you're responsible for your immigration status. So it is imperative that, because you are responsible, that you know what the latest changes are, so you can make really smart decisions as to how to navigate through this process. And in addition to our news channel, we're having these webinars every week, and we also connect with us on Facebook, Twitter, LinkedIn, or YouTube. I'd love to hear from you. Send us your questions, your comments, your concerns. Like I said, my goal here is to make sure that you have the latest information so that you are able to navigate this very difficult process in these very trying times the best possible way you can. So I look forward to hearing from you in one of these forums. But until then, this is Lakshmi Challa, and I'll see you again next week, same time. Take care, be safe, and thank you for joining us today.